bem-vindos a mais esse painel do curso de inverno promovido pelo CEDIM. Good afternoon, everyone. My name is Vladimir Feijó. I'll be the mediator of this second panel of the day. It will be the 17th one during the 18th winter course of international law promoted by the International Law Center, a branch of CEDIM, and sponsored by the Konrad Adenauer Foundation and the Minas Gerais branch of the Brazilian Bar Association. I'm honored to give the floor to the speaker of the lecture, The Color Line in the International Law. Professor William Shabbos will be speaking. He is a professor of international law at Middlesex University in London. He's also emeritus professor of international criminal law and human rights at Leiden University. He is distinguished visiting faculty at Paris School of International Affairs, Sciences Po. He's also officer of the Order of Canada and member of the Royal Irish Academy. Professor Shabbos, welcome. Please, the floor is yours.
Thank you very much, Dr. Feijó. I'm very pleased to be with you here. I wish I could be in person in Brazil and that we could all be in the lecture room in Belo Horizonte, where I was many years ago lecturing as part of this program. We're making do with these temporary measures of online classes and online lectures. And so it's very nice to be here with you, even if it's only virtual. I'm going to talk to you about my ongoing research. I say ongoing, I've actually completed the manuscript of a book on this subject, which is now in the course of being prepared for publication, with a title that will be perhaps adjusted slightly, but basically takes the title that I've given to this lecture. And I have an article on that subject that will be published very soon in the Max Planck Journal of United Nations Law, and that will be available online. But I have no text to refer you to. It's something that I've been working on for a year and a half or so, and it has been inspired by concepts that may be familiar to you. You may know about the third world approaches to international law, TWAIL, which is a whole school of public international law scholarship. Also, discussions and debates that are going on, not just within international law, but in many other disciplines, about what we call the decolonization of the curriculum. And so my work is very much in that spirit, although I've chosen to focus on one dimension of it, which is the color line. It overlaps with third world issues. It overlaps with decolonization, but it's focused more specifically on issues of racism and racial discrimination. And what my research has done is develop two main ideas. One of them is the importance that issues of racial discrimination have played in the human rights activities of international organizations, and more specifically of the United Nations, how central the racial discrimination of nations in the field of human rights since the organization was established in 1945 or the beginning of 1946. Secondly, what I've tried to show that countries of the global south, particularly Africa, but countries in particular that have a large diaspora of Africans, like Brazil, have played in advancing the agenda of racial discrimination and more generally human rights within the United Nations and within international law. The the phrase, the color line, was used very famously by a great African-American scholar, W.E.B. Du Bois, more than 100 years ago. In, I think, 1903, he first wrote it. And he spoke about the color line being, he said, the color line is the issue of the 20th century. The 20th century is the century of the color line. He didn't invent the phrase. The phrase had been developed by another African-American activist, Frederick Douglass, I believe, some decades earlier. But Du Bois's statement is famous, and there's nothing original in me citing it. It's cited in many, many articles. He had the insight to understand how much the 20th century would be about color. He could have said the global South and the global North. These are modern day phrases. He would not have said the third world. That notion didn't exist until the 1950s, I believe. He spoke about the color line, and it was partly his way also of affirming the relationship and the solidarity that he and his people felt, the African Americans, with the people of Africa and with other places of the African diaspora. The first real landmark in international law, so I'm speaking now about international law. Du Bois was not an international lawyer, but as you'll see, he became very engaged with promoting the issues within international organizations. And the first place where these issues arose and where he was present was the Paris Peace Conference following the First World War. Paris Peace Conference of 1919 was a very, very important event in the development, the progressive development of international law. The First World War had come to an end. The former empires, not all of them, the British and the French empires would remain, but the empires of Central and Eastern Europe, Prussia, Russia, Austria-Hungary, Turkey, the Ottoman Empire, had all either collapsed or were in the course of collapsing. And the world was in many ways being remade. And there were many countries that came to Paris to participate in this exercise, including countries who had not been dramatically affected by the First World War. African Americans in particular tried to send delegations. Du Bois was successful in getting to Paris, although he had no official role. He was in the corridors, on the periphery of the Paris Peace Conference. There were others. Marcus Garvey, another important African American activist, attempted to go to Paris, but was blocked. He could not get a visa. Visas were required by the United States, and he simply couldn't get there. He managed to send a representative to Paris. People came from elsewhere in the world, NGOs, activists, colonized peoples, attempting to advance their concerns as the treaties were being negotiated that really remade the world and remade international law in 1919. And well, the conference ends at the end of 1919, but some of the aspects of it continue into 1920. And of course, they then lead directly into the establishment of the League of Nations. Well, one of the very interesting developments at the Paris Peace Conference is when Japan, which is considered one of the great powers, Japan is the great Asian power, and it attends, it's one of the 5 principal powers, along with the United States, the United Kingdom, then called the British Empire, France, and Italy. And Japan comes with one of the issues that it wants to promote and that it campaigns for is the inclusion in the Covenant of the League of Nations, which is being negotiated, of a clause recognizing what was then called racial equality. And Japan promoted this. It was supported by China. This came to the attention all around the world. Colonized peoples were aware of this campaign, and it followed it in the newspapers, including in the African American press in the United States. And when it finally came to be decided whether to include this clause, it was blocked by two powers, the United Kingdom and the United States. And in particular, there in the session where this had to be voted upon, who essentially vetoed it. Although the rules of procedure didn't allow him a veto, he simply said, we're not going to have it, was the American president, Woodrow Wilson. Woodrow Wilson has a heroic profile. The Office of the High Commissioner for Human Rights in Geneva, and in many parts of the world, he's viewed as a great pioneer of progressive development of international law and international organizations. But he came from the southern United States, and he was a white supremacist. He was a profoundly racist individual. And as president, he had actually set the clock back within the United States on the integration of people of color into the public service. He established rules. People of color had managed to integrate in the public service in Washington, in the US government, and Wilson put an end to that and set the clock back. If any of you have seen the recent film by Spike Lee called Black Klansman, there's a wonderful scene in there where Harry Belafonte, the great African-American musician, who's acting, he's an actor in the film, and he's telling young people about a racist film in the United States, The Birth of a Nation, which glorifies the Ku Klux Klan. And he points out in the film how Woodrow Wilson, the president, had shown this racist film in the cinema of the White House in 1919. So Wilson blocks this, and in effect, the message and the memory, the recollection of this event is going to haunt the debates about equality and racial discrimination to the next stage in the development, in the next major stage in the development of international law, which is the conference in San Francisco in 1945, where the Charter of the United Nations is adopted. In the interim, of course, we have developments that are relevant to the issue of racial discrimination within the work of the League of Nations. It was not a human rights organization, the League of Nations, but it had two areas where some of these issues arose. It basically had a two-pronged approach to with human rights dimensions. One concerned the protection of minorities, but that was essentially within Central and Eastern Europe and in the Middle East. If you want to talk about the color line, this was the color line. The people on the north of the color line were governed by the minority rights provisions in the League of Nations, the body of law adopted by the League of Nations. Not all of them, because the minority rights protections of the League of Nations applied to the countries that had been created following the Second World War, and not to the countries that created them. So the great powers were immune to any international supervision of how they dealt with minorities. But the new countries of Central and Eastern Europe and in the Middle East, they were subject to it. As for the other half of it, the southern part of the monitoring of the League of Nations, this was done through the mandate system. And this dealt only, not with all of the colonies in the world, not with the entire colonized world, but with the countries that had been, they were not countries yet, with the territories that had been German colonies prior to and during the First World War, and that were in effect reassigned. It was a glorified and polite form of colonialism, if you want. But within that system, there was a significant degree of monitoring of the conduct of the powers with the mandates, and several of them were in Africa. And those issues involved racial discrimination. And the country that was the worst and that had the most serious problems was Southwest Africa, which was assigned to South Africa. And Southwest Africa from 1920 until 1990 is going to be a theme in the international confrontation of racial discrimination until 1990, when apartheid ends and Southwest Africa becomes independent Namibia. And of course, apartheid ends in South Africa. Well, at the San Francisco conference in 1945, there are some efforts to push the issue of racial discrimination onto the agenda, but they're not very successful. W.E.B. Du Bois, the African American who was present at the conference in 1919, he's there in 1945, campaigning for the same thing. He's joined by a Chinese diplomat named Wellington Koo. Wellington Koo, who goes on to be a judge at the International Court of Justice. Wellington Koo had been present at Paris in 1919 as well. And Wellington Koo attempts, but briefly, to insert a clause in the Charter of the United Nations, like the clause that the Japanese had promoted in 1919. But there's a third person who's been present at the Paris Peace Conference and who returns to play a big role in San Francisco, and that's Jan Smuts, who was the South African leader, who was himself a profoundly racist individual, a man who had, in some respects, noble humanitarian ideals that he tried to insert into the Charter of the United Nations, but who understood that they applied to the civilized so-called peoples of the North and not to the people of color of the global South. And Smuts is the man who's credited with drafting the preamble of the Charter of the United Nations, and that explains why there's no clause about equality, racial equality, or racial discrimination in the Charter, in the preamble, and in the Charter of the United Nations. If you read the histories of human rights within the United Nations, they typically begin with a discussion about the slow development of human rights within the United Nations, beginning with a phase of drafting major instruments, in particular, the Universal Declaration of Human Rights. And in that activity, the heroes are the intellectuals of North America and Western Europe, notably René Cassin of France, Eleanor Roosevelt of the United States, and with a role being acknowledged to some people who might be from the South, but they were in effect Europeanized intellectuals, Shah Malik of Lebanon and Zhang Punchen of China. But there's another story that I try to develop in my book that I think has been overlooked, maybe neglected, maybe deliberately omitted from the histories of human rights in the United Nations. And that is the role that countries of the South played in promoting not the standard setting, not the negotiation of documents, but actual activity of the United Nations in the area of human rights. When the Commission on Human Rights, which was the first human rights body in the United Nations, assembled in January of 1947, the representative of the Secretary General, in his opening remarks, said that the General Assembly of the UN, which had met the previous year, had already made some important developments in the area of human rights, and he referred to 3 resolutions that had been adopted by the General Assembly of the United Nations when it met in New York City in late 1946. What he didn't say, perhaps it didn't seem significant to anybody at the time, was that all 3 of those resolutions were proposed not by the United States, not by Britain, not by France, by countries of the South. So let me tell you a little bit, just briefly, about those resolutions. The first one was a resolution proposed by India dealing with the racist treatment of people of Indian origin in South Africa. There was, and there is today, a diaspora population from India, workers who were taken as in a form of slavery, migrant wage, what's the word? the indentured workers taken from South Asia to South Africa to work in agriculture in the 19th century. And they stayed on, and they were subject to various forms of racial discrimination by a regime that was notorious already for its racial discrimination. And South Africa, India had tried to raise these issues within the British Empire, which was then the Commonwealth, but unsuccessfully. So India, which was in 1946 still not really a fully independent country, it was one of a number of semi-countries that participated as founding members of the United Nations. One of the other famous ones is Ukraine, which was a founding member of the United Nations. So India comes and says, we want a resolution that calls South Africa to task for how they're treating the Asians, the people from India within South Africa. The Western countries, South Africa's friends in Europe, in North America, said, but you can't do this. You can't raise these issues here because we have a clause in the Charter of the United Nations which says that the United Nations cannot interfere in areas that are essentially of domestic concern or domestic jurisdiction. Article 2, paragraph 7 of the Charter. It was put into the Charter as a way of countering the handful of rather frail, feeble references to human rights that we find in the Charter of the United Nations. Well, those objections were overridden, and South Africa was successful by a very bare majority in the adoption of its resolution. But what South Africa had done was pushed open the door of human rights monitoring within the United Nations. For the first time, it was the first session, but it had pushed open the door that the countries of the North thought was locked, bolted shut by the Charter, whereby the United Nations could intervene in areas of human rights within a member state. That was the first resolution. Some people say that the Indians were really only concerned with the people of Indian origin in South Africa, but that's not true because the Indians also fought South Africa on other battlefronts within the United Nations, including the efforts by South Africa to annex Namibia, Southwest Africa, to South Africa. And when South Africa tried this, the Indians took the floor in the United Nations and said, why would the people of Southwest Africa want to join South Africa? They'll be worse off if they join South Africa, because then they won't at least have the supervision of the United Nations or of the League of Nations within South Africa. So that's the first resolution. The second one that doesn't get much attention these days, but was significant for many years, was a resolution condemning racial discrimination proposed by Egypt and supported by Saudi Arabia, of all countries. And that resolution was adopted after first being blocked, again, by the main powers within the United Nations. Egypt succeeded in pushing this onto the agenda and getting it adopted. And in a way, that resolution filled the gap, the hole that had been left in the Charter about dealing with racial discrimination. And then finally, there was the resolution on genocide. The resolution on genocide it's resolution number 96, and it's often treated as being kind of a relative, closely related to a companion resolution, resolution 95, on crimes against humanity. But in reality, these two resolutions exist in a tension, and the resolution on genocide was proposed in order to correct the resolution on crimes against humanity, because crimes against humanity, the resolution on the Nuremberg principles, resolution 95, because that resolution did recognize the principle that there were no crimes against humanity in peacetime, and that crimes against humanity had to be related to an international armed conflict. And that had been very deliberately affirmed at Nuremberg by the United States and other countries, so that they would keep the treatment of African Americans and other minorities out of the scope of international law. So genocide the resolution on genocide sort of opens the door. And who proposes the resolution on genocide? Cuba, Panama, and India, 3 countries of the South. When the Cuban ambassador takes the floor in the General Assembly to propose the resolution, he says, we're doing this to fix a problem that results from the Nuremberg judgment. There are other developments. My time is short. I'm not going to linger on them. I've written them up in detail. One of the important other developments at the time are the efforts to start petitioning on human rights issues to the United Nations. Who does this? Well, the lead is taken by the African American organizations in the United States, including W.E.B. Du Bois, to whom I've referred. And they prepare very detailed and elaborate petitions that they attempt to submit to the United Nations dealing with racial discrimination in the United States. And they are quietly pushed aside by the bureaucrats within the United Nations and by the powerful countries who say this has no business being before the United Nations. The African Americans will return in 1951 with a petition on genocide, charging the United States with genocide in its treatment of African Americans. And that too will be brushed aside. It's a fact that in the 1950s, the human rights activity within the United Nations is dominated by the countries of the North. And not much happens. When does it start to get energetic? When does the activity really happen? I mean, an example of the lethargy on human rights can be seen in the very slow progress of the adoption of the 2 covenants on human rights, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights. It's tedious how they advance. Advance is probably not even the word. By the end of the 1950s, they've really made little progress in a decade towards adoption. 2 dramatic things happen in 1960 that will change all of that. The first is something on the ground, which is a terrible massacre at Sharpsville committed by the South African army and the police, where they murder 69 people who are participating in a peaceful demonstration against racial discrimination. And that takes place in March of 1960, and the day is still commemorated today as the UN Day Against Racial Discrimination. The other thing that happens is that later in the year, 17 new countries are admitted to the United Nations. The United Nations, when it starts, is composed of barely 50 countries, and only 4 of them are from Africa: Egypt, Liberia, Ethiopia, and South Africa. By the end of the 1950s, we start to see a few African countries join the United Nations, Ghana, Tunisia. But in 1960, 17 countries are admitted, and 16 of them come from Africa. And the following year, still more are admitted. And these new countries from the South, from Africa, at the top of their agenda within the United Nations is human rights, but in particular, racial discrimination. There's a proposal that has made its way up, bubbled up in a way, through the human rights organizations of the United Nations from something called the Subcommission on Human Rights, which no longer exists. The Subcommission proposed that the General Assembly adopt a declaration on racial discrimination. And when the African countries arrive, they say, why just a declaration? We should have a treaty. And so they insist that the United Nations General Assembly adopt not only a declaration, but a full-blown treaty. And that's what happens. And in 1965, still before the 2 covenants on human rights, which were supposed to be the next stage in the progressive development of human rights before they can be adopted, that will happen in 1966, the following year. The General Assembly in 1965 adopts the International Convention on the elimination of all forms of racial discrimination. It's an important, fabulous instrument. The convention is ratified today by 183, I believe, states within the United Nations, and it has played a huge role. Of course, it deals with a broad range of issues relating to racial discrimination. One of the issues that is sensitive when it's being negotiated and that is obstructed by the countries of the North, but contested by the countries of the South, is how it deals with the issue of incitement. Does it deal with the incitement, racist incitement that promotes, that results in violence? Or does it deal also with racist incitement that results in hatred? The Western countries say it should be confined to incitement that results in violence. And the Africans say, no, it's got to be broader. It's got to deal with incitement to hatred. You know, incitement to violence is a crime in most countries already. It wouldn't really do anything to require states to have a crime of incitement to racist violence when they already have a crime of incitement to violence, which is the case in the criminal law of virtually every country. And so the result in the International Convention on the Elimination of Racial Discrimination is the inclusion of a clause dealing not only with an obligation on states to address and to prosecute incitement to racist violence, but also to racial hatred. There's another interesting development that's also coming very, very directly from the Global South in the 1960s, and it concerns the area of international criminal law. Now, again, if you read the histories of international criminal law, you will learn about the Nuremberg trials and about some of the efforts like Genocide Convention, and then the initial efforts to draft a statute of an international criminal tribunal that happened in the late 1940s and into the early 1950s, but that all came to a stop in 1954 when the General Assembly decided to postpone any further development on the subject pending a definition of the crime of aggression. And that will only happen in 1974. And then it takes time to get started again. And finally, things only really begin at the end of the Cold War. And I must confess to you, it's a history that I've largely taught over the years as well. But I've had a change after studying the subject more. And I realize now that there's actually a lot going on in the area of international criminal law in the 1960s and the 1970s. But it's all coming from the South. And it's about apartheid and other forms of racial discrimination being conducted by colonialist and neo-colonialist regimes in Southern Africa. So by the beginning of the 1960s, most of the northern part of Africa has become properly independent. But there are still several Portuguese colonies in Southern Africa and elsewhere in Africa. But the main ones are in Southern Africa, there's South Africa, and there's Southern Rhodesia, modern-day Namibia, which becomes kind of a breakaway British colonial state. And so it's broader than South Africa. And of course, it's also in the territory that South Africa has been mandated to supervise and to assist towards independence, which is Southwest Africa, modern-day Namibia. So all of that is being addressed. And the African countries start insisting that resolutions dealing with Southern Africa include clauses recognizing that apartheid and racial discrimination are crimes against humanity. And the European countries, who were the ones who were taking claim to the heritage of the legacy of the Nuremberg trial, all say, no, we've already defined crimes against humanity at Nuremberg. Crimes against humanity only apply in wartime. They don't apply in peacetime. Don't change the definition. Why do they resist it? Because they are quietly, and sometimes not so quietly, continuing to trade with and to support South Africa. And so they're opposed to this. They oppose these resolutions. They're adopted. by strong majorities, but with the opposition of essentially all of the countries of the North. And this later further develops into a very important treaty, which is the Convention Against Apartheid, adopted in 1973. It's a treaty that today has 100 states parties, none of them from the global North, none of them from Europe or North America. They refuse to ratify it. Today, the crime against humanity of apartheid is in the Rome Statute. It was part of the compromise when the Rome Statute was adopted in 1998. But in the 1970s, when it was being negotiated and prepared, there was fierce opposition to this treaty from the countries of the North. It's a great treaty. It's a treaty that advances international criminal law. It revives the idea of an international criminal court that has gone dormant, that had gone dormant in the 1970s. And it put it back on the agenda. It led to the UN requesting an expert to prepare a draft statute of an international criminal court, which is produced in 1980. All of this is going on with the resistance of the countries of the North. One other thing, included in the Convention on Apartheid is a clause on universal jurisdiction. And the countries of the North are fiercely opposed to this. They don't, now, today, they all love universal jurisdiction, and they make it sound as if they've always been in favor of it, but they haven't. And they were opposed to universal jurisdiction, which was being promoted by the African countries, because they were afraid that they would be prosecuted for collaborating and assisting the apartheid regime, and they would be prosecuted before the courts of African countries under the principle of universal jurisdiction. Well, this is some of the history. There are other developments. There are a series that are held dealing with racial discrimination, starting in the 1970s, another one in the 1980s, and finally the great conference that takes place at Durban, South Africa in 2001. And these two were great, great developments in international human rights law. The United States in particular, along with its ally Israel, managed to oppose every one of these conferences. Somehow the United States has managed to try and obstruct and to stay outside virtually every major development in the United Nations dealing with racial discrimination. And that continues to the present day. It continues to the present day, where only 10 months ago, there were debates and resolutions adopted within the General Assembly of the United Nations dealing with racial discrimination that had been, again, that had become more acute within the UN, partly because of the whole phenomenon of Black Lives Matter, the murder of George Floyd. And 10 months ago, the United States was trying to undermine and obstruct the development of resolutions to deal with racial discrimination at the United Nations. So these are some of the pieces of the development of the subject. Things changed to an extent in 1990 with the end of apartheid. Apartheid is the central issue in racial discrimination for many, many years. And when apartheid ends, there are efforts within the United Nations to refocus all the activity on racial discrimination that takes it away from the dimension of the color line. And engage religion and so on throughout the world. But at Durban, at the conference in 2001, there's an effort to recalibrate this, to correct this. And this leads to the resolutions, the discussions, and all of the activity of what we call people of African descent. And so now we have a working group. We've had it since the end of the Durban conference, a working group on people of African descent. And this has made a huge contribution, as well as the special rapporteur on racial discrimination. So I say that this debate ongoing since the early 20th century about racial discrimination, about the color line. It's not over. Some of you may be historians or may have studied history at university. You may have heard of a famous British historian who wrote about, his name is Eric Hobsbawm, and he coined a concept where he spoke about the long 19th century and the short 20th century. So for him, the long 19th century actually began in the 18th century with the French Revolution in 1789 and finished with the outbreak or the end, finished with the First World War, 1914 to 1918. And then he had the short 20th century that began with the end of the First World War and that ended in 1989 or 1990 with the end of the Cold War. But I think that there's also a century of the color line that W.E.B. Du Bois spoke about at the beginning of the 20th century. And that century is a long century, and it's not over yet. So let me conclude with just a few comments about an issue that I think is going to be the issue that is the issue of the 21st century, if you want, or that is one of the unfinished issues of this whole debate. And it involves the color line, it involves third world approaches to international law, it involves decolonization. And that's the issue of reparations for colonialism, the slave trade, and other historic abuses. And that is a debate that was addressed at Durban. It had emerged following the end of apartheid. It had become a more central issue. People had been talking about it for decades, but it was addressed in Durban with a kind of a compromise at the Durban conference in 2001, with some ambiguous formulations and with reservations by different states. At Durban, there's a famous phrase in the declaration that's adopted that was the result of a compromise that says that slavery and the slave trade are a crime against humanity and would have been a crime against humanity in the past, had they been committed today. And this was put in by a number of countries of the North who were very, very concerned that if they recognized that slavery in the past was a crime against humanity, then they would be subjecting themselves or exposing themselves to claims for reparations on the basis of slavery. Well, the countries of the South of Africa, of the Caribbean in particular, objected and made reservations to this statement in the Durban Declaration. And that issue continues to simmer. I understand that countries of the Caribbean are preparing a legal challenge in the British courts on the issue. I'm pretty confident that this is not an issue that's going to be solved in a courtroom, at least we're not going to break the logjam on it in the courtroom. It's a difficult argument to make. One of the issues we have to confront is this question of intertemporality in international law, which is a very nice and clever notion that countries of the North developed, saying, listen, we have to apply the law that was the law at the time the events took place. But of course, the law was being made by the countries of Europe. And so today they say, well, that was the law. But the people that they're applying it to today, they weren't involved in making the law. I don't understand why they're subject to the rule of intertemporality. They weren't involved in the lawmaking and they weren't consulted about the rules. So this debate will continue. And I think that there are going to have to be adjustments. Only a few weeks ago, I had the pleasure of testifying before a committee of the Belgian Parliament on these issues where they're discussing this. They're confronting it. Belgium finally is confronting its colonial past, and they're debating these questions. In Belgium today, they're commissioning monuments to their colonialist heroes, the racist leaders of Belgium who inflicted such misery on the people in Southern Africa, in Central Africa, particularly in the Congo. And they're examining this question. But when it's carried through to its logical conclusion, it has devastating consequences for the wealthy countries, because it provides us with a lens to understand global inequality. That global inequality is in some way a result of the inequalities that derived from these colonialist and ultimately racist regimes. So I think that the 21st century, which is where the color line is still present, is going to address this. Perhaps not in my lifetime, maybe not within the next few decades, but we have surprises in international law. We have issues, as I'm sure you know, that are well accepted today that were unthinkable 30 or 40 years ago. Changes that take place. It's a dynamic area, one that's influenced by political developments, and this is going to require great political developments. But it will happen. I'm confident of it, and that it's part of bringing an end to this poisonous doctrine of racial inequality that has haunted humanity for several centuries. With that, I'm going to conclude and hand the chair back to Dr. Feijó, and I'll be happy to take your questions or hear your comments. Thank you very much.
We thank you, Professor Shabbos. The lecture was excellent. So far, there's no questions from students, so I'll make my own. Of course, the topic of racism and other discrimination, it's about power of a group upon other groups. And as a political scheme or world affairs, the topic of sure will be discussed with some difficulties, especially because internal affairs also play an important role. Yourself commented on the United States issue and its constitutional problem that resides for centuries now. Nevertheless, it's an important issue and will become more and more pressed since the population of the world and also the world economy will be shifting in this century and the next one. Of course, Africa will be a part of the big share of the growing population in the second half of the century. It already is, and will press on in this political agenda. Well, my question is, since there was established the 2030 agenda, there were no, or not at least many topics on racial discrimination and racism and indicators that can be measured upon it. How come can we expect this topic to be discussed in the United Nations and its forums?
Well, thank you. I mean, I think what you're referring to is simply, it's a confirmation of the sensitivity of this issue and the fact that it's far from resolved. I think there were people, I don't know if you remember when Barack Obama was elected president in the United States, and there were people who said, well, now we're in a post-racial society. It's over. But of course, it wasn't over, as we've seen with George Floyd and so many other events, with the election of Donald Trump and the fact that racism is, the United States is not post-racist. But I don't want to pick entirely on the United States, because there are many other countries that are confronting similar issues. It's an issue that's being confronted in Europe. It's a very mixed issue, and on the one hand, there are developments that are phenomenal. In the United Kingdom, where I'm coming to you from, I live in London. We have the prime minister is in his final weeks and he's about to be replaced. There are two candidates now in the running, and one of them is a man of Indian descent. He's a man of color. The other is a woman, by the way. This is not the Labour Party. This is not the left wing. This is the right wing party. It's quite astonishing. And 50 years ago, the Conservative Party, they hardly had any women members, and they certainly had very, very few members who were people of color. I think it's largely true even today in terms of their membership. But at the leadership level, we have that. So we see these quite remarkable developments and changes in some respects. And yet we had a statement, I think yesterday, from the president of Hungary, talking about how Hungary, Orban, said that the Hungarians want to preserve the Hungarian identity and they don't believe in race mixing. I mean, it's Nazi talk from Orban in Hungary. So all of this is to say this is an issue that is being that is in many ways central, is important, and hasn't been resolved, and that countries are confronting, and it's about power, and it's about recalibrating, about equality, and because when people of color take their rightful place, they displace other people who and some of them resist that. So all of this is to say it's a mixed message, something that I haven't studied thoroughly, but that I have an intuitive sense of, is that alongside there's been resistance to the issue of racial discrimination within the United Nations, not overt, not people saying, oh, this is not an important issue, but regularly you'll have countries, mainly from Europe, countries in the North, Canada, and so on, who will say, yeah, racial discrimination is important, but we have to talk about other issues, about sexual orientation and disability. And some of that, I mean, I far be it for me, I'm not opposed to those issues. I don't want to see them marginalized or neglected, but it becomes a way sometimes of countries opposing the place of racial discrimination at the center of the agenda. And there are people, and I'm sure when my book appears, who will say that I'm obsessed with racial discrimination, and why should I be? That there are other issues and other discussions that should be had. Let me just give you one final example where I think this tension still manifests itself. You will know, Vladimir, about the famous the history of the International Court of Justice in dealing with South Africa, and a series of cases that began first with advisory opinions requested by the General Assembly going back to 1950, I think, or 1949, and then this famous contentious case on South Africa's administration of Southwest Africa that took place in the 1960s. It was generated within the South. The countries that led it were the two African members of the League of Nations from the beginning when the mandates were started, Liberia and Ethiopia. And they took a contentious case against South Africa at the International Court of Justice that was that first had to get over the hurdle of admissibility, which it did, only to be rejected in 1966 by a judgment, the most controversial judgment ever issued, I think, by the International Court of Justice, that was a tied vote, and where the president from Australia cast the deciding vote and had the case thrown out as being inadmissible. And of course, the South, much of the world, was furious when that happened. 3 days ago, on Friday, the International Court of Justice issued a ruling on admissibility in the Gambia versus Myanmar case. And there were two separate opinions, one by the Chinese judge, Judge Su, and the other by the ad hoc judge for Myanmar, Judge Kress. And they both talk about the judgment in the South Africa case in 1966. it continues to haunt the court. Well, I don't want to focus on that case. I want to talk about another case that has arisen. There have been a number of cases in recent years at the International Court of Justice based on the International Convention for the Elimination of All Forms of Racial Discrimination. There's one ongoing right now between Ukraine and Russia. There are two others between Azerbaijan and Armenia. And there was one that was thrown out by dealing with Georgia. Well, in a recent ruling on that case, where the convention was invoked by Qatar against the United Arab Emirates, it was just over a year ago. I think it was in February of 2021. It was declared inadmissible, the application by Qatar. Qatar was complaining about the treatment of its citizens within the United Arab Emirates who had been expelled and subject to various kinds of measures. And they said this was a violation of the Racial Discrimination Convention. The issue boiled down to the interpretation of the definition of racism in the International Convention on the Elimination of All Forms of Racial Discrimination. And the majority, I think 9 or 10 judges, I think it were 9, because I think our great Brazilian judge, I know a graduate of your university, Antonio Cansado, an old friend of mine, we've been friends for almost 30 years. And Antonio was already ill, I think, when this was issued, and he didn't participate in the judgment. But in the judgment, or did he? In any case, when the judgment was issued, the judges, there were several dissenting judges who favored a broad definition of racial discrimination in the convention. Who were they? The judge from Jamaica, the judge from Uganda, the judge from Somalia, the judge from India, and the judge from Japan. It was like a color line in the International Court of Justice. And I think a few commentators have noted this, but it was a very striking geographic difference, because this was, after all, this is not an earth-shaking issue. It was about admissibility. It wasn't about the merits. And it was simply about whether measures of discrimination taken against a people in another country fit within the definition of racial discrimination. And the judges from the South said, we should have a broad definition of racial discrimination. And the other judges, mainly from the North, said, we should have a narrow definition. So I give that as an example of how, there's the International Court of Justice, haunted by the racial discrimination since the 1960s, and it's still there. Now, I want to be careful here. I'm not accusing the judges of the majority of being racist or anything. It's just about how people view the facts and the law. And people from the South, people of color, are likely to see it differently than people of the North. That's what happened in the International Court of Justice. That's the color line.
Professor Shabbos, I have no doubt that it's a topic that probably for some people it involves bias points of view. It's a topic that involves culture, that involves power, and of course we'll have to accompany and keep talking about it for the next years or so. I don't know how many, probably decades. Due to the lack of time, we'll have to finish this panel. I thank you on behalf of Cedin and every student, researcher, everyone that will be taking this course. For the public, the course will resume tomorrow. Thank you very much.
Thank you.
Thank you so much, Professor Vladimir.